Uh, Good afternoon, everyone. Welcome you all for this program uh, on the tribunal aspects leading to a GST tribunal. In fact, tribunal is yet to start its operations, but meanwhile, uh, the procedural aspects as to how the tribunal will function has been recently notified. Though the framework of it was already available through the provisions under the GST Act and rules, but how the tribunal is going to function procedurally, how it is going to operate has been notified recently. Nevertheless, lot of things could be experienced when the actual functioning of the tribunal starts, because most of the process involved till the hearing will be operated through a portal. Even hearings are said to be a mixture of both virtual and physical, depending upon the requirement of the litigant who are going to request what they will be comfortable with. So we have to wait and see how these particular process is going to turn around, how it is going to be operated, and many of the aspects which we are going to discuss in the course of today's discussion can help the participants to understand and at least start thinking certain aspects relating to tribunal appeal, whether to go, if you are to go, what all the preparations we need to make, how it is to be made, all those aspects has to be ascertained. I mean, at least some information and some idea they will be able to get. But however, detailed aspects of it, they will experience only once it starts operating, and lot of technical hiccups may be there in initial stages, and which we have to bring it to the attention of the registrar, who will be the concerned authority in the tribunal to address these issues, and the registrar, supported by joint registrar or a deputy registrar or the assistant registrar at a different levels of the hierarchy, will be of use, where we can bring our aspects to their knowledge and attention. So this is briefly to talk about this particular tribunal. And in fact, I know most of the tax practitioners and the taxpayers anxiously waiting for starting of this tribunal. I will give a present status to our understanding. At various places, the infrastructure aspects are still being looked into, or at some places it's taken up. The places are identified, but it's still the setup is yet to happen. The website of the GST tribunal, the design and the trial runs are happening. In fact, for a shorter duration, they have left that particular thing to operate, but then they subsequently they have withdrawn it. So we have to wait and see how it is going to be functioning. And at the same time, any authorized representatives are required to register themselves in this GST tribunal website to enable them to file their client's application, etc. So with these brief thing about this tribunal, and hoping that it will happen as early as possible. We can only wish for it, because it is not within our hands. We are getting promises every third month that in next 3 months it will be started. But it is more than now 17 to 25 to 8 years crossed, but still we are keeping our fingers crossed, waiting to see when it is going to start. I don't think that it may become operational at least for further 3 months. Okay. So why is that important? Because for us to collate all our cases, where all we are we have got orders by various appellate authorities. We are awaiting to take a further action, whether we need to take a further actions or not. All these aspects has to be experienced. So let's proceed with me to lead this entire discussion. There is Chartered Accountant Ashika Agarwal, who is into GST litigation and leading the litigation wing of Venu and Vinay. At the same time, another chartered accountant, Jagadeesh from Vizag, who also practices litigation and other compliance related practices. He will be also driving this session, covering certain aspects of this procedures. I will be pitching in this entire process wherever I feel that practically I need to add certain aspects for the benefit of the members. Ashika, okay. The session flow we have designed in this fashion. Firstly, I'm going to give a brief overview of the appellate mechanism. After that, Ashika is going to run through what this GST tribunal is, how it is constituted, who will be there, which matters will be heard by which of the tribunals, those aspects of it, and what the powers, jurisdiction, composition, all those things as a conceptual level. Then Jagdish will be uh, getting into explaining us about the procedural aspects of the tribunal, which has essentially come up through these procedure rules. And at the end, we will have the floor open for the members to seek a question. In the intermittent, if any question which comes up to the minds of the participants, you are invited to put those questions in the chat box, which will be noting down and possibly will be addressing at the end of the session. So, Ashika, next slide, please. I want to explain the entire litigation process in the GST. GST law, as you all know, is a new law. Lot of confusion or mistakes in addition to non-compliances and evasion taxes have happened in the GST. Maybe what we would have come across is litigation due to mistakes and errors mostly, may not be with the reason of any intention to evade taxes, but nevertheless, the department, the government officers, the authorities always looks any default to be done with the intention to evade taxes. How is that important to draw a line between these? One, the time frame within which an action to be taken by the authorities limited when it is a genuine errors and mistakes. Whereas in case of a intended evasion or non-payment of taxes, obviously the authorities would get a longer period for proceeding and acting upon it. And furthermore, the penal consequences and the penalties which would get attracted are different in both the scenarios. In addition to that, recently, I do not know how many of you are aware, there was an amnesty scheme which was brought out, wherein they said if there is any genuine errors for the period 17, 18, 19, 19, 20, if the taxes are paid before 31st March 2025, the interest and penalty will be waived off. However, this scheme is applicable only in cases where the proceedings was initiated by the authorities in cases where there was no intention to evade taxes. Essentially, it is called as Section 73 notice. But as I was mentioning little while ago, the authorities always pursue any default as a case where it is done with intention to evade taxes. So, which would mean that they would not invoke a notice under Section 73, instead, they would issue a notice under Section 72. However, in this entire scheme of things of the GST law, though a notice might have been issued saying that you have done all these acts with evasion intention, but finally it is found by the appellate authorities that no, such instances did not exist and it is a genuine default. The appellate authority is empowered to change the course of the proceedings from Section 73 to 74. Now, saying so, as I mentioned, the scheme where somebody was served with a notice under 74, subsequently these appellate authorities, which we are going to talk about, changes the course of proceedings from 74 to 73. Then even after the appellate authority's order, the time limit will be available for going forward. So this is something which many people are interested to go for appeal. But now appeal. Now it comes to the appeal. Appeal mechanism are concerned. First, there is a called as appellate authority. I think I understand that there is some issue about my voice. I think hopefully now it is clear. So firstly, any orders, before passing any orders, as a principles of natural justice and the scheme designed in the GST law is that the taxpayer should be issued with a notice, giving him an opportunity to explain his case why such proposition in the notice is not sustainable. And after that hearing, an order is required to be passed. So the officer who is supposed to hear the case and pass the orders are called adjudication officers. Because why I am stressing upon this is, in the course of this discussion, off and on we will be using this word adjudicating authority or adjudication order, adjudication officer. That means the officer who has asked to decide the case after hearing the taxpayer's submissions or the points which has been across, then that officer is an adjudication officer and the order what he passes is an adjudication order. Now, any orders passed by adjudicating authority that will become final unless it is appealed against. So, if an order is not appealed, then it becomes final, irrespective of the fact, however wrong that order is. Somebody looking at itself may say, what is this? It is senseless. It is idiotic. Nothing, it is completely wrong. But still, it will be a valid order, enforceable order. The amount stated therein will become recoverable unless that order is appealed to the higher authority and that order is quashed. So it becomes important for any taxpayer, any person to file an appeal against any order passed against him, and merely talking to the officer, approaching the officer without taking a legal action against that order is of no use. So one has to keep in mind that they have to file an appeal against any adjudication. Whom they have to file appeal? Any orders passed by adjudicating authority, the appeal is required to be filed before the appellate. Who is this appellate authority? If any orders are passed by an officer below the rank of joint commissioner or additional commissioner. Then appeal will go to the joint commissioner appeals or additional commissioner appeals. However, if the order is passed by the joint commissioner or additional commissioner, then the appeal will be filed before the commissioner appeals. Okay, so this is the mechanism which is built, keeping the hierarchical system. For in Karnataka, as far as Karnataka is concerned, there is a different practice in state and different practice in center. As far as the state is concerned, no orders will be passed by an officer above the rank of deputy commissioner. So all the orders passed by the state authorities as an adjudication order are passed by the officer, either deputy commissioner or below. Hence, appeal lies only before joint commissioner appeals as far as state is concerned in Karnataka. When it comes to center, considering the monetary limits, if the monetary limits are higher than what is specified, then joint commissioner or additional commissioner will pass an order. Then appeal will be filed before commissioner. In other cases, it will be passed by the officer below, and appeal will go before either joint or additional who has been nominated to that particular position. So this is the first appellate body chapter, and which is running already. And most of the cases they have filed appeal. And today it is not a focus point for our discussion. I'm just giving you a brief. Then any order passed by this particular appellate authority, then we have to file appeal before the tribunal. Please note, I repeat, any orders passed by the appellate authority or first appellate authority called, appeal has to be filed before the GST tribunal. Now, not only this, there's a one more type of order which we can file appeal before the tribunal. Any orders passed by the departmental officer, the higher officer can review that order and see that there is some error, it's illegal, in the interest of the revenue, department's revenue. So they may feel that the order passed is incorrect, improper, illegal. So they can take up that matter, that higher officer, as a revision proceeding. Revisionary, they are called as revisionary authority. Section which gives this authority is section 108. So section 108 gives an authority for the revisionary authority to revise the order of the lower authorities and then give a notice against that proposition and pass an order under a revision proceeding. Such revisionary order is also appealable before the tribunal. So if you see the PowerPoint, the third bullet from the middle, appeal against the order passed by appellate authority or a revisionary authority. Okay. How is this tribunal? What type of benches? That further Ashika is going to explain. Then, if I am not happy with the tribunal's order, then what is the remedy? I have a remedy to go to High Court or to Supreme Court. Which of the matters will go to High Court? Which of the matters will go to Supreme Court? If any tribunal has got two wings or two aspects, one is the state bench and the principal bench. If any orders are passed by the principal bench of the tribunal, then appeal against that order will go directly to Supreme Court. It will not go to High Court. If the order is passed by the state benches, then the appeal against that order will go to High Court. In addition to this, any orders passed by the High Court is also appealable to Supreme Court. But please note, all the orders passed by the High Court is not automatically I can file appeal to Supreme Court. Once High Court is passing an order, at the time of passing an order, either High Court voluntarily says or the appellants or defendant says, please consider that we want to go for a appeal to Supreme Court. the High Court is going to certify, yes, this order is suitable to file an appeal before the Supreme Court. Only upon such certification by an High Court, then only appeal against the High Court order will go to Supreme Court. Otherwise, the order of the High Court will become final. Similarly, any orders passed by the appellate tribunal, unless appeal, will become final. There is some concept of pre-deposit, etc., which further in the course of this discussion, the Ashika or Jagadeesh is going to discuss. So at that point in time, I will bring in some more aspects about this appellate mechanism and structure. I think with this basic discussion, I now hand over the proceedings to Ashika to take the things forward from here. Please, Ashika.
So, as we came to know about that, appellate tribunal is basically a second appeal level. Now we are standing in May 25, and till the financial year 2021, most of the cases has been closed under 73. 74, it can be open and it can going as there is an extended time limit of 5 years. But under 73 section, till 2021 is over and 21-22 period is going on. Now we have witnessed, we have filed an appeal before appellate authority, and we have also seen how the appellate authority a system of appeal mechanism is working under the same. The forms which need to be filed and how the cases are decided. Based on the order received from appellate authority is where we file an appeal before appellate tribunal. Now, what does this appellate tribunal consist of? Now, there are two benches in appellate tribunals. One is principal bench, another is state bench. Now, there will be only one principal bench, which will be in New Delhi. But there will be multiple state bench or union territory benches, which will be across the country. Now, there are why these two types of benches are there, and these two types of branches also have different jurisdiction and different subject matter where you can file before them. So it's important to understand that what these two benches are and what it consists of. So if you will see principal bench, there will be a 4-person. One will be president, one judicial member, one technical member of center, and one technical member of state. Now, when you comes to state or union territory bench, there will be only 2 judicial member because already president will be appointed as a principal bench, and at the state, vice president will be appointed. So state bench will be consist of 2 judicial member and 2 technical member. One will be of the state and center. If you see that the way their composition has been done is by keeping in mind that question of law and question of facts, both is taken care. That's why it is a mix of judicial and technical members are kept there. In the law, specifically, it has been provided who can become the president, who can become the judicial member and technical member. For a president, it is obviously they majorly prefer Supreme Court judges or a Chief Justice of High Court. For a judicial members, he must be either an advocate or a district judge with a minimum year of experience. Criteria is there. And technical member of the center will be the officer of Indian Revenue, and for state, it will be the officer of state revenue. So based on those department, members will be selected and they will preside over these benches. Now, this division of benches is not only relevant to the extent that I'm saying this consists of taking care of question of law and fact the way they have made, but it's also important to understand the jurisdiction which they enjoy. Another important point over here is if there is any defect in this appointment or if there is any vacancy, means you might feel that my case should be listed before this person and that person is not qualified to become the member. So there may arise a case where if adverse order has been passed, you might feel as it has been passed by a member who is not qualified to become a judicial member or a technical member, then that adverse order will still prevalent. It will not get void. This is specifically provided under the Act that no act of the that no act or proceeding of the appellate tribunal shall be questioned or shall be invalid merely on ground of existence of any vacancy or defect in the constitution of appellate tribunal. So it's very clear, even though there may be defect in appointment of these members, because of that, the order passed by them will not become immediately or ultimately void. That will prevail until and unless appeal is filed. Now we come to know what the benches are, principal and state. We have to also understand the power enjoyed by appellate tribunal. Now, appellate authority, appellate tribunal, they are the quasi-judicial proceeding they are regarded as. So it is specifically mentioned that any proceeding which is happening before appellate tribunal will be regarded as a judicial proceeding, and they enjoy the power of civil court. Though they don't follow the code of civil procedure, because they have been given a power to frame their own rule for the purpose of conducting their business, but they have been deemed to be a civil court and proceeding to be judicial proceeding. So if there is any violation, like in a court, if you violate the conduct of the court, you can be penalized. Similarly, in the appellate tribunal also, if anything which is done which is not in the code of conduct, then obviously there will be also a consequence about on the appellant also, and it can be also on the person who is representing the case. As it enjoy the power of civil courts, so it includes summon and enforcement of attendance. So if it's required, appellate tribunal that any person should be come and should give his uh, sorry, should come and should give his witness that this is what it is, this is what has happened. They can summon any person if they required for the proceeding. Also, they can ask for procurement and any documents which is in the public record. They can ask that, and a public authority will be required to produce those documents. Even the appellant or department officer, if they ask for, they have to produce it. It can receive evidence on affidavit. It can issue a commission for examination of witness or documents. Now, another important thing is, if you will notice, as it was discussed in the starting, that when the hearing happened, we are given also an opportunity to take adjournment. We can take max 3 adjournment before the appellate tribunal, which is similar to appellate authority. Before, not even appellate authority, below line the officer, below the appellate tribunal also, any proceeding which is happening, I can take adjournment up to 3 times. So if after giving an opportunity of being heard, if before the appellate tribunal nobody appeared, then appellate tribunal has a power. It can pass an ex parte order either, or it can dismiss the appeal due to non-appearance of the person. Both. There is a difference when ex parte order and dismiss the appeal. When I say dismiss the appeal, they are not deciding the case on merits. They are just dismissing the appeal on ground of non-appearance. But when we say ex parte order, it is different in the way that over there, even though party is not present, based on the documents or details available on record or filed with the appeal and lying with the department officers, based on that available record, they will pass the ex parte order, where they will discuss whether they have considered the issues, and if they have dropped, why they dropped. Even dropping can also happen in ex parte order. If they have confirmed, why they have confirmed. Ex parte order will be also a speaking order. So both that two powers also is enjoyed by the by the appellate tribunal, and any other matter which may comes from time to time. Now this powers which has been given to appellate tribunal, with this power in GSET rule, that is Goods and Service Tax Appellate Tribunal Procedure Rules, specifically mechanism has been laid down how the same to be done and to be followed. So if you will see, GST is more procedure oriented. Maybe it appellate tribunal or other proceeding. For each and every proceeding, there is a specific form prescribed. specific manner has been prescribed, even specific time limits has been prescribed in order to do the compliances. It is saying that if procedure or system is followed, to some extent, justice itself is taken care. So the way they have designed, the way the procedure they have given, and way the forms they have given, they at their best, government has tried to make sure all falls in the system and everything goes one by one in the process required. So here we have given what are the powers and what are the rules which are relevant with respect to that powers. So if any one of you, when approaching to tribunal and any of this scenario arise, you have to make sure you make an application in the relevant form and follow the prescribed procedure. It's not only for you, even department also need to follow the same thing in order to take the benefit of this things. Now we discussed that there are two types of benches. Now we also came to know for first appeal order, I mean to say appellate authority order, we can go and appeal before the appellate tribunal. Now the question which arises, as there will be two benches, whom should I go and file the appeal? So all the order of appellate authority against which appellant or department wish to file an appeal will go to state benches. Now, however, if that order against which we plan to file an appeal involve any issue in relation to place of supply, then it will go directly to principal bench. So there will be no state bench involvement. In case of place of supply, you have to file an appeal before principal bench. Place of supply issue, I mean to say where there is a classification, tax type classification issue, interstate or intrastate. So that will go to principal bench. Then come another is anti-profiteering. Now, what is anti-profiteering? Recently, government also said that they for anti-profiting, they have given a sunset clause. March 25, case is over. Now, no more anti-profiting case will arise. But in anti-profiting, what is happening? As we know, there is a shift from pre-GST regime to GST regime. Now, while shifting from old to new, there has been change in rate. There has been allowance of input tax credit, which were earlier restricted. As this credit were earlier restricted, cost of product get high because this IETC disallowance become the cost of the product. Now, when they change this, as ITC now not becoming a cost, government expect that the benefit which they obtain by way of ITC by reduction in cost should be passed on to the customer or the person who are buying it. Similarly, if there is a rate change, earlier it was a higher, lower rate, now higher rate, that also they are making sure that it is that rate of tax which has been changed is also passed on to the customer. So to make sure that the supplier who took the benefit of this has actually passed on to the consumer or not, this anti-profiteering concept was bring it under GST, and accordingly, any of the customer or person who feel that this benefit has not been passed on, they can go ahead and file an application before anti-profiteering authority. This majorly we have seen in construction industry, where initially on from pre-GST to pre-GST to GST regime, they got a benefit of ITC, which was earlier not allowed. So over in construction line, many people have filed for it. Some has come in favor also. Maximum has come in favor also, where the person who has applied for application got some refund of the amount paid. So for this anti-profiteering, there was no appellate mechanism. Now they have said this also, against if any order of anti-profiteering is there, which is adverse, not considering the grounds presented, can also now be filed before principal bench. Then any other case which may be notified by the government from time to time or on the recommendation of GST Council. Now, why we are discussing this? Because if you will notice, between principal and state is a subject matter jurisdiction. There is no monetary jurisdiction, no territorial jurisdiction will be there for state to state. But principal is one only, principal bench one. So there is a subject matter jurisdiction. For if subject matter include place of supply, anti-profiting, or any other case specified government or recommended by GST Council, then it will go to principal bench. Otherwise, the cases will be lying with the state bench. Another thing to note in the act is they have said that this benches has also a power to admit the appeal. Now they can reject the appeal, but this is a discretionary power where they can reject the appeal if the quantum involved of the tax is below 50 or equal to 50K. So if you are having any issue, now when I say issue, you have not to see total demand. When we say total demand, it doesn't mean tax plus interest plus penalty. So I'm not talking about the case where tax plus interest plus penalty coming to 50K. I'm talking about the case where individually, not individual issue wise, but in the order where the quantum of tax determined, if it is below or equivalent to 50K, against which you have gone for an appeal, then benches enjoy a discretionary power whether to admit or not to admit. So that also you have to take care of it. If you have any appeal which is around this 50K, then just make sure that you present your case properly. Otherwise, based on monetary limit, bench may not admit this appeal. Now with this bench composition, there is also called hearing composition. Now in the SISTET, pre-GST regime, which still SISTET hearings are going on, we see the concept of single member bench and double member bench. So where the single member bench will hear the cases not involving question of law or small monetary limits. Similarly, under GST also, they have specified this to hearing composition. They have said that single member bench will be listening to the cases where question of law is not involved and where the case which is involved is less than 50 lakhs. But these two things will happen only when it is approved by president. So principal bench president, if approved, that single member can hear the cases which is below 50, then even in state bench, having single member can hear these cases. However, if it is not approved, then it need to be done by double members. For double member, there is no limit. They can hear even below and above below. But based on the issue involved, it will be decided based where the state bench will be constituted, how many members will be there in state bench, how they are deciding that in which chamber, how many members will be deciding that case will be is on based on state to state composition, it will be decided whether it will be here by single member or a double member. But this is what the criteria has been laid down under the law. But if anything which relate to question of law, that will be here by double member only. When we say question of law, we basically means where the interpretational issues are there, where simply it's like 2A versus 3B. There it can be heard by single member also. But if you are questioning 16.4 time limit to avail the ITC, then it become a question of law which will be heard by a double member.
I would like to just add certain points for till now, whatever you have covered. Can you just go back to one more slide, please? Yeah. I think in the course of the presentation, Ashika was mentioning about the principal bench, state bench, and all those things. To put it very simply, tribunal is one tribunal. Just understand it like that. But head office of the tribunal is at Delhi. That is what is called within bracket as a principal bench. All other benches, so-called state benches, are nothing but branches of the tribunal. So head office and branches. Certain powers are retained by head office, not delegated to branches. If you understand in that manner, the head office is supposed to hear the matters pertaining to place of supply. Why? because place of supply is a law which two states are involved. Because the question would be decided which state is going to get revenue if the place of supply is decided in favor of either parties. So if it is given to the state bench, probably it is thought there may be a bias on the part of the state benches as was originally designed. They may tilt towards deciding in favor of the states. So hence they wanted to keep that unbiased and has kept this aspect of place of supply to be decided by the head office, that is principal bench. Now it comes to that anti-profiteering thing. Actually, let me tell you, anti-profiteering is not an appellate mechanism what we are talking about today. It was a separate set of process to determine whether there exists a profit, anti-profit or not, whether the benefit is passed on, various factors. There was a separate authority which was constituted, but it was not so successful. And so hence all the cases which I think they wanted to transfer all those cases to competition commission. Later on that also did not work. So now those cases of anti-profiteering have been now assigned to tribunal, but not all the benches of tribunal, only the principal bench at Delhi only will hear the matter. So to in nutshell, there's no difference between the bench, both the benches can hear both the, all type of matter based on the jurisdiction assigned by the president, based on the area. But whereas in case of the any appeal, which is primarily involving a place of supply, or among various issues, one of the issues is also place of supply, then an appeal has to be filed before the principal bench. So this is how the mechanism works. What is this bench? A bench is generally constituted of 4 members. In head office, there will be a president who is actually a retired judge and etc. A judicial member, again, there's a set of qualification who can become that. There is a technical member who is from the department side, one from the state authorities, another from the central authorities. So effectively, 4 people are made as a bunch of people who are called as bench. But please note, when the matter are being heard, it is not that 4 people will be sitting over there and I have to argue before the 4 people. No, it is not so. It's only two people who are going to sit on the table, that is a bench, and hear the matter. Who these 2 people will be? One judicial member, one technical member. So one judicial member and one state technical member, or one central technical member. So once there's a bench of 4 people, parallelly there can be 2 separate courtrooms where the matters can be going on parallelly. At the same time, Ashika also mentioned about a single member. If the amount involved is less than 50 lakh and also does not involve a question of law, then which is basically a routine. It's only a matter of fact, some smaller issues are concerned. So they say for easy and a fast disposal, they say it can be heard by one judge enough. There's one member is a member like a judge. So he himself can sit and decide and conclude the matter. There's no need of two people sitting. So this is what is how we need to understand this entire process. When it comes to state benches or the branches, whatever we talked about, in Karnataka, they have said 2 benches will be set up. Both are in Bangalore. That means totally 8 people will be there. 4 judicial member, 2 technical member center, 2 technical member state. But which means there is going to be a parallelly of 4 courtrooms running. So that is how it will be a setup, and that is how so many number of cases can be heard. Though we are seeing that so many cases are pending, if all the benches became operational, it is not going to be, too much difficulty for them to take up and dispose of. And this is only a matter of time till they have to be trained. We have to get used to it. We have to experience that particular process and get our presentation done, all those other things done. I think when it comes to this admission part is concerned, admission part, this principle was there even the earlier Central Excise Law as well, before the SESTAT, the Central Excise Customs Central Services Appellate Tribunal. Whereas, to my experience, there was no such appeals which were rejected for admission on this ground. So, though this is there, this will be there in the statute book. In my understanding, that may not be enforced so strictly. And also, there may be a situation where each year there may be a 45,000, 45,000, 45,000. So, always you can make a representation that please admit it because there's a recurring issue or there's other matters. Next year it is having a bigger amount. So you can always make a request not to reject it at the admission stage and ask them to admit it. So these are some things which are practically which may be required to know in this entire tribunal process. Over to you, Ashika, for proceeding further.
In this, I want to add one more thing, that dismissal, see, like sir pointed out, it has not generally tribunal does that in the past what has happened. But the thing is that dismissal of this appeal also doesn't mean if there is a subsequent year with higher amount, then you can't file an appeal. One. Second, dismissal does not mean that court is saying you are liable to pay tax. It is just dismissed due to quantum. So still it can be decided on merit for further subsequent period, and even you can contest at a lower level if it is of a recurring nature. So you should not assume that if it is rejected, it is equivalent that it has been passed against me confirming the demand. Both are two different things. Now, with this background understanding about the benches, about their jurisdiction, how the hearing will work, we need to understand why we laid down first this thing is that we as a applicant, as an SSC or as an authorized representative, when we are going to appear before the tribunal, we should know who all will be there, how it to be represented, and who will be sitting there, so that case can also be means can be prepared accordingly. Now coming to the appeal procedure. Now, as we see in first appellate authority, what is happening? We get the adjudication order. After receipt of adjudication order, we were filing an appeal in GST APL 01 specified format through GST portal. Online, we are filing. And at the time of filing an appeal, we were making a pre-deposit, which is 10% of the disputed tax. After filing of appeal, our appeal get admitted. Over in the appellate authority also, there is a procedure of admission of appeal. So online when we file, we immediately get one provisional acknowledgement, which is given in GST APL 02. And after submission of manual, we also get the appeal number allotted. Though under GST law, as per the rule prescribed, if order is appearing online, we are not required to do the manual filing. However, in Karnataka over here, the department is insisting that once you file online, you submit us the copy for their record purpose. And on submission, they are generating the appeal number and sharing over email to the SSC based on the email ID you given in the appeal form. So GST APL 1, we file the appeal. Then GST APL 02 for provisional acknowledgement. And then we get the final acknowledgement. And after that, hearing is scheduled. Based on the hearing, the facts, law, whatever presented, an order is passed with a summary of order in GST APL 04. Now, similar fashion, even for tribunal, there are prescribed form and due dates. So when we are going ahead with the filing of appeal before GST Appellate Tribunal, we have to file an appeal in specified form GST APL 05. There it was 1, here it is GST APL 05. Now, this appeal filing also comes with the time limit. Like before appellate authority, it is 3 plus 1. When I say 3 plus 1, I mean to say 3 months appeal time limit has been given. With that, we have been given extended period of 1 month to file with condonation of delay. So 3 plus 1 is before appellate authority. Now, in case of before appellate tribunal, it is 3 plus 3. So I have a time limit of 3 months from the date of order received. I have to file an appeal, or I have to utilize extended 3 months with condonation of delay to file the appeal. Now, however, as we know, tribunal still not formed. Therefore, we are not required. So over here, over here, the deadlines which has been given for filing an appeal is still not active. Now, what the change has been done, they have provided date to be notified. 3 months or date to be notified, whichever is later. So when the tribunal will be formed, obviously government is going to notify the date for the all the past order which has been filed, which has been passed by the appellate authority, where based on that date notified, we have to file an appeals within 3 months. From the date they will notify, from that I will have 3 plus 3. And I have to, being an SSC, I have to file an appeal in GST APL 05. Now, appeal provision is also there for department. It's not the case only SSC can go for appeal against the order. Even where the order has been decided in favor of the SSC, department can also go for an appeal. Similarly, like it was there before appellate authority also. In appellate authority, there was a specific appeal form APL 03. In case of tribunal, it is APL 07. So if department is going for an appeal against the order of appellate authority, they will file an appeal in APL 07. They also have a deadline 6 plus 3. So in our case, is a reduced timeline. In totality, we get 6 months. Here in department, they get in totality 9 months. But over there, their time limit runs from order date. In our case, time limits run on communication date. So there is a difference. It may be a case order passed, but when it is communicated to you, from that date, you have to see. Communication can be on GST portal. So date on which they have communicated on GST portal of the SSC, from that date, time limit will start running. But as I said, as tribunal is not formed, so from the date it will be notified by government, from that date, this time limit will run. Now, it's not only important to know your appeal time limit, it's also important to know the department time limit, because there has been an instance in the past where the though department has filed an appeal, but they filed after the time limit prescribed. So at that first instance only, you can get the department appeal dismissed, being time barred. So it's a, like we say, it's important to know our enemy also, to know what approach and how we should go ahead. It's a similar fashion. So this is how the department appeal time limit you have to also check. The moment we file an appeal, again, every filing will be happening online. So it need to be done through portal only. There will be separate GST portal, GSET portal for the purpose of GST tribunal, through which we have to file an appeal. So this mechanism, like appellate authority online mechanism, will be there for GSET appeal also. On filing of online application, again, I will get one acknowledgement, that is APL 02. Similarly, in appellate authority also, it was APL 02. In the appellate tribunal also, it is APL 02. So in that, they will give me an acknowledgement, which will basically give me my appeal number and my appeal admission date. This is very important. Why I'm saying? Because if appeal admission, once the appeal is admitted, then only it will schedule for hearing. Till the time is appeal is not admitted, if there is any defect, then registrar and bench have the power to dismiss my appeal on ground of defective. That we will be discussing in our subsequent slide. What will happen if the appeal file there is certain non-compliance or there's some document missing, or the columns or the row which need to be filled has not been filled. That all will be taken care in subsequent slide. So over here, I'm just giving you the mechanism, what will what will be the steps. So first we will file an appeal, then we will get our acknowledgement. Again, after getting our acknowledgement, hearing will be scheduled. Now over here in tribunal, cause list concept come. Cause list are basically the list of hearing which is scheduled for a day. Like in system tribunal, at the end of the week, they will give me the list of hearing which is scheduled for the day in the next week. So full from Monday to Friday, whatever hearing is scheduled for the next week, I will get that full list of the hearing. And based on that, I can see which is my number, when is my hearing scheduled, and what is it listed for. Because in cause list, there are concept of miscellaneous application, regular hearing. So it need to be checked if any miscellaneous application you have filed, then first miscellaneous application will be addressed. Once the miscellaneous application is addressed, then only it will be scheduled for regular hearing. So hearing will be scheduled based on after the hearing of the similar way the appellate authority over there you present your case, you have to present before appellate tribunal. But over here, the thing is that here separate department officer will be also standing beside you, who will be pleading from the department side that why the order passed with confirmation of demand is valid. And here you will be standing defending your case that why the order pass is not correct. Based on what the hearing happened, what the facts presented, based on that, judge will decide what the order will be. And when it is decided on a main part, main merit, it is called final order. With that final order, like under GST, we know the concept of summary of order. Like when adjudication officer pass, they have to pass summary of order in DRC 07. When appellate authority has to pass, there will be one detail order. With that detail order, there will be a summary of order. When appellate authority pass, they have to pass a summary of order in APL 04. Similarly, appellate tribunal will also pass a detail order speaking. With that, he will also issue a summary of order in APL 04. But this summary of APL 04 order will be issued by the jurisdictional officer. So this tribunal will just give the detail order, which will be obviously pass on to the jurisdictional officer, and jurisdictional officer based on order pass will upload the summary of order in APL 04. So this is how the mechanism will work for appeal. Now, when we have filed an appeal, we have also the option to withdraw the appeal. There may be a case to some situation you might have decided that you want to withdraw the appeal. Or it may be a case that appeal which you file have been dismissed. Then also you can again file the appeal. So if you want to withdraw the appeal which you yourself have filed, now appeal withdrawal can be done by you also, and if department has filed an appeal, they can also withdraw. So there is even a provision for withdrawal of appeal. For withdrawal or appeal, there is not specific time limit prescribed, but it is said that it should be done before the order is passed. So basically, it should be done before the hearing happened. So if anyone wants to withdraw appeal, make sure if it should be done before the main final order is passed or before the hearing happened. And when we file this application for withdrawal, tribunal has to decide within 15 days whether they will accept this withdrawal or not. Normally, they will going to accept because it will reduce the litigation, because it's upon you, you have come forward to withdraw it. Then when we file an appeal, there is a concept of cross objection. Now, being an appellant is presenting its case that this is what it is, this is what it is. Now, appellant can be either a SSC, appellant can also be a department. When an SSC file an appeal, then department has an option to file a cross objection, basically a counter to the appeal file. So basically, they will also present their facts that why they don't agree what the appeal is filed by the SSC. Similarly, when the department file an appeal, as an SSC, I have the also option to file a cross objection that what department have went for appeal with this ground is not valid. So I have to file a cross objection. For that cross objection, there is a separate form APL 06, and there is also a specific time limit to file this cross objection, that is 45 plus 45 days, so total 90 days. And I have the date from which it will be counted is from the date of communication. So what happened whenever an appeal is filed in tribunal, it is a 4 set we submit. 4 set of our appeal document we submit. So 2 is with the bench, judicial member, technical member. 1 will go to commissionerate, means in which commissionerate your case lie. And 1 will be go to the officer who has passed the order, that is appellate authority. So normally we file 4 sets of appeal. So as we are filing 4 set of appeal, my commensurate will also come to know that I have filed an appeal. So they, if they want, they can do the cross objection against the appeal file. Similarly, like I am filing this 4 set, department also when they file the appeal, they also are filing the 4 set, and 1 set of the appeal filed by the department will come to know. So that's the communication that department has a file and appeal against you. And after that, I have the option to file a cross objection against the appeal filed by the department. Similarly, the same right is also with the department. Now, as I said, that after filing of appeal, admission of appeal will happen, hearing will happen. Based on hearing, the final order will be passed. This is what the flow will be happening. And all this will be happening online. Second thing is to decide how many appeals we have to file. I said appeal set. Now there can be a case that there may be 1 show cause notice, 1 order, 1 appeal. But there can be a case of 2 show cause notice, 2 show cause notice merge into 1 order. Then how many appeals? Because number of appeal will depend upon number of order. So if adjudication order has 2 number, like in the past in pre-GST regime, it was said order number 67 to 69. So it became 3, 67, 68, 69. So we were required to file 3 appeal. So based on number of adjudication order, not appellate order, adjudication order, first order, based on number of order, it will be decided. Similarly, sometime it happened, 3 adjudication order is decided by the appellate authority in 1 appellate authority, 1 order, being the case be same, issue involved is same, but only of different period. So appellate authority, while passing single order, addressing all 3 adjudication order, if you will notice in appellate authority, order number will be showing 3 numbers. 1 order, but having a number of 3. So this, even if appellate authority order is 1, but adjudication order is 3, then we have to file 3 appeal before the appellate tribunal. Now, there can be a case that in 1 order, multiple parties are involved. If multiple parties are involved, each party is considered as one and individual. So every party who is involved have to file their own appeal with respect to issue involved in that single order. So based on number of party also, number of appeal will depend.
Ashika, I would like to just add certain points over here. I do not know how many of the participants here have understood this concept of cross objection. Okay. I want to emphasize certain things and explain this concept. Generally, what we understand as a cross objection is somebody is filing appeal and other party is filing a counter to the same. Okay. But the way and the manner in which it is designed in this GST law is not the same. It is not necessary that each and every appeal has to be coupled with the cross objection with other party. I'll take an example. There is an order where they said it is for the period 17-18. Notice is issued in 2024. Notice was issued under section 74. Now, the issue was a wrong classification by virtue of which rate of tax was held to be actually 28%, where the taxpayer has paid at 18%. Now, the appellate authority holds, yes, what the adjudicating authority has held is correct. Your goods falls under heading so and so, so and so, and liable for tax at 28%. But however, the appellate authority says, since there is an interpretation issue, section 74 could not have been invoked. Hence, I set aside the demand on the point of limitation. So what effectively happens, the part of the order is against you, part of the order is in your favor. But consequently, there is no demand. Now, since there is no effective demand, you decided not to file appeal against that order. 3 months got over, further period of 3 months also getting over. Now, department comes and files appeal after that particular period, of which they have a 6 months time limit. So they file that appeal somewhere after 5.5 months. Then you will get to know after 6.5 months that the department has filed an appeal against the limitation aspect. Now, what will be decided in appeal, whether the authority is right or wrong in saying that demand was barred by limitation or not. Now, if that question goes against you, your original issue of the classification is already lost because you have not filed appeal against that part of the order. So, this opportunity is given where you come to know that the other party has filed appeal against that order and you have left some portion of the order not appealed. Once you get to know the department has, the opposite party has filed an appeal, so you are free to contest the issue or a part of the order which you are not appealed against. So to be on a fair side, that is where they say, once you get to know the other party has filed an appeal, you have been given 45 days to file a cross appeal. Instead of reading a cross objection, read it as a cross appeal on any part of the order which you are not either to appeal. So thereby you get a right or a life to that portion of the order which has not attained, which otherwise would attain finality. So hence, this aspect has to be kept in mind. Once in any order, there are multiple aspects of a same issue. I repeat, multiple, only one demand is there, but it involves multiple aspects. Like, it may be valuation, it may be rate, it may be limitation, it may be an exemption. So one of the findings in the order may be against, but other findings may be there in your favor, based on which the demand is dropped. If the other party is filing an appeal, whichever the part there's a finding against you, to bring in that aspect of it in appeal, this cross objection will work. So you need to be very, very careful when you are going through the order, though in your favor, whether any part of the order is against you, highlight that portion, keep it ready. If by chance the other party files an appeal, be prepared to file a cross appeal or a cross objection within 45 days of the receipt of that appeal. Due time is 45 days. Okay. So, yeah, I think this is how we need to look at this cross objection aspect of it. It is not merely finding a counter up points to the grounds of appeal. It is not that. Okay. Hope that everybody understands this aspect of cross objection, which we need to be aware of. Ashika can proceed further.
As you saw, we were discussing about the appeal filing by the department. Now, for department to file an appeal, there is a monetary limit. So if it is like we are discussing about the tribunal appeal, so if where the quantum of demand which is involved is below 20, they are restricted or they are asked not to file an appeal. Now, in the pre-GST regime also, there was this condition. So wherever department has filed a appeal and where the quantum of quantum of total demand was below 10 lakhs, that appeal were automatically were getting dismissed because below the monetary limit. So similarly, under GST also they have designed this. If quantum is below 20 lakhs, then they are saying department no need to file the appeal. But this quantum doesn't mean that they are not allowed to appeal, not allowed to file the appeal in every cases. There are certain exclusion. Now, another thing which is to be seen is how this quantum to be decided. So for that also there is specifically circular has been provided, circular 207, which deals with it. And it has been said how this quantum will be determined. So where there is a case which involve the tax issue, when I say tax issue, I'm not just saying non-payment of tax or short payment of tax. I'm even including ITC, input tax credit issue, wrong availment or wrong utilization. So where the quantum in the head of tax, if I say specifically, in the head of tax need to be checked. If it where the tax involvement is there. But if it is only a penalty case, interest case, then only penalty and interest quantum need to be checked. But where tax is involved, you no need to check tax plus interest plus penalty. Only tax quantum will be checked. So if tax quantum is below 20 lakhs, because there may be a case, we have seen how the systems are working. There are cases where 2009-10 hearings comes now. So if we go in that fashion, tax may be 2 lakh, 3 lakh, but due to delay of 10 years, 15 year, interest will be so much that it may even cross the tax, making it total more than 20. So here they have specifically said that tax need to be checked where tax is involved. Where tax is not involved, it's just only interest, penalty, late fee. Then based on that, those quantum 20 lakhs monetary limit need to be decided. Now, this monetary limit also you have to check, but most of the time, like in system practice, department itself says that this is below monetary limit and it get dismissed. So no further things happen. But if it is not highlighted by department where they have filed an appeal, you can highlight the fact that it is below in the restricted monetary limit. So therefore, appeal will be dismissed. And as I said, don't assume dismissal of appeal as a passing of order in favor. It's just appeal is dismissed due to monetary limit without discussing anything on the merit. However, this monetary limit also comes with the exclusion. So there are certain cases, even though it is below 20, department can still file an appeal if it include like constitutional issue. Now, constitutional issue, let us take example of refund of inverted duty structure. So there was a section 54.3 which says that in case of inverted duty structure, refund is eligible only when input rate is higher than output tax rate. But the thing is that the way the formula was designed previously, it was only considering input ITC, not considering the impact of input service ITC. Because when we make the payment of tax, it does not matter. It is input service or capital goods. Total ITC, which is there in a credit pool, can be used for payment of tax. So over there, 54, which is the section which was a challenge. So that can be one of the constitutional issues. So if such types of issues are there, then even if it is below 20, department can still file the appeal. Second, rules or regulation validity, like rule 2A versus 3B. As number of people have filed that rule 36.4, which was inserted, which allow us to claim ITC based on GSTR 2A, and it also comes with cap 20%, 10%, 5%. But there was no provision under the GST Act till Gen 22 that is 16,288. So that is also one of the means. I'm just giving you few example based on what been covered under exclusion, where even below the limit, department can still file the appeal. Now, government board instruction and circular. So, like notification, which extended the time limit for passing of order for 73. That has also been challenged. So, in such cases, department can go for appeal. Another, that if this is of recurring or interpretational issue, it is of such nature that it is an industry-wide issue, or it's law interpretation, or it is coming in one or multiple SSC in every period. In those cases also, it can be, means this limit will not be applicable. And other cases where as and when will be prescribed by the board. Jagdish, over to you.
Jagdish, I think Jagdish can take over. Jagdish, you're not audible. Jagdish, you're not audible. Ashika, are you able to hear?
No, sir.
Jagdish, can you just exit and probably re-log in? No, I think you are presently on mute. I think Jagdish, better you log out and log in. Can you please speak out? Jagdish? Jagdish, you are there? Jagdish, can you speak out?
Is this okay, sir? No?
Now it's okay. Now it's audible.
Oh, okay, okay. Let me share my screen. Just a second. Sorry, my keys are not working. Okay. So now we'll discuss about the procedures. The yeah, yeah. Now we'll see the appeal filing procedures. Recently, the procedure had issued by the tribunal itself under section 111. Yes. So now we'll see the procedural part. What are all the contents of the appeal? An appeal document should contain the title of in the Goods and Service Tax Appellate Tribunal. Plus, in addition to this, it also should contain the details of order and also the details of authority who has passed that order. So these details we have to mention in the appeal document. And also appeal should be numbered paragraphs and stating the distant statement of the facts, allegation and points. In the initial part, information, the following information should be provided. We'll see what are all the information should be provided. One, the full name of the appellant, parentage and GSTN, description and address of the each party. And this information should be provided only once. It should not be repeated in the document. Let's say there are two appellants, appellant number one, appellant number two. There are three respondents, respondent one, respondent two, respondent three. Like that, we have to provide it in the later stage. But in the initial part, we have to provide the details of all this information, and party should be numbered consecutively. So let's say each party on a separate line with a description. If a party dies, let's say if an appellant one dies and legal height is taken up in person of the party dies, so he will be added as a next party. I mean appellant number three. Like that, we have to give the number to the parties. So we'll see the next part. So the format requirement, and the format are also provided by the GST Appellate Procedural Rules 2025. So what are all the formats? The appeal should be typed neatly. It should be typed or neatly handwritten on A4 size paper. So if you see here, it specifically mentioned the size of the paper. Whereas in the SESTAT, it's mandatorily specified it should be on the legal size paper. So here for the GST Appellate Tribunal, you should use the A4 size paper. And number of pages and all the pages should be numbered, and you have to prepare the index for the whole document. And you have to maintain the separate sheet for the statement of the facts and the grounds. You should not mess all that. And all the document should signed and verified by the respective person. I mean, if the appeal is filed by the appellant, it should be filed by the appellant. Or if you give an authorization to any authorized representative, then it can be signed by the authorized representative also. So this is how you have to prepare your appeal document. And what are all the, now we'll see what are all the documents required to accompany appeal form. So if you are filing an appeal against an order, you have to provide the certified copy of original OIO, original order, that is adjudication order or the appellate order, and all the relevant documents and all the including the relied upon document should be enclosed along with the appeal document and the appeal fee. So along with the how much appeal fee that we will discuss in the later slides, along with the pre-deposit, it for the GST Appellate Tribunal, you have to pay the appeal fee also. So there is an exception for the commissioner. If there is an exception for the department file appeals. So if any appeal is filed on the direction of the commissioner, then an attested copy of order is acceptable. That means that it's need not be certified. So non-filing of document, the registrar or authorized officer may return incomplete documents for correction in case there is any shortfall or in case of any deficiency in your submission. Then he can return the documents. So later you can rectify the defects if there are any defects, and that rectification should be done by appellant within the 7 working days. So now we'll see the registrar powers. Registrar may allow additional time. In addition to the 7 days, he may allow you up to maximum of 30 days to rectify the defects. So even after giving 30 days of time. If you have not rectified your defects, in that case, if he is not satisfied, then he may reject it. I mean, he may, before rejection, he has to give the specific reasons for rejection. And after that, if he is not satisfied, I mean, registrar is not satisfied, then he has to refer to the tribunal bench. Then the tribunal bench will accept or reject it post giving the post hearing. I mean, now we'll see the pre-deposit part. Anyway, in the first appeal, as Ashika said that we have to make the pre-deposit of 10% of the tax, disputed tax. So in addition to the first appellate pre-deposit, for GST, for filing an appeal before appellate tribunal, we have to make the pre-deposit of 10%. In addition to 10%, we have, again, here we have to make the pre-deposit of 10%. That is 10 plus 10. First appellate, in the first appellate, you have to pay the 10% pre-deposit, and in the GST appellate tribunal, that is the second appellate, you have to again pay the 10%. Total 20% you need to pay the pre-deposit amount. So if you have admitted any of the liability, in that case, you have to make the 100% payment of tax, interest, penalty, and late fee if any is there. So this is the preliminary condition, one of the conditions to file an appeal. And in case of penalty order, then in that case, you have to pay the 10% of penalty. That means order is passed only for the penalty, not for the tax interest. In that case, you have to make the 10% of the penalty demanded. So if we have, there is one circular. We'll see that circular 224. If we have already made the pre-deposit amount, but you have made that payment through DRC 03, that is voluntary payment. In that case, you can adjust that payment through DRC 03A against the pre-deposit amount. How to that is already given in the circular number 224. And refund of pre-deposit. If the demand is dropped, either in the first appeal or the second appeal, before the appellate tribunal, in that case, you can claim the refund. Along with the interest also you can claim. So for that, you have to file an online application in the GST portal, not in the appellate tribunal, GST, not in the GST portal. You have to file a refund application in the GST portal. And you can also claim the interest of the rate of 6% per month as per 56. So now coming to the hearing part.
1 minute, back.
Yes, yes, ma'am.
Back. One more, back.
This one only, ma'am.
So basically, how this appeal admission work is, I'm talking about first CSTAT. When we go there, we go for submission of appeal. Over there, the registrar, there will be one person sitting who is basically collecting your appeal, registrar. So before taking the appeal and before putting a stamp that it has been submitted, they verify certain criteria. So they have their own checklist where they verify the things like appellant full detail is properly there or not. Authorized representative mention whether authorization is there or not. Pre-deposit has been made or not. If made, it is made as per the amount which is payable or not. They will see that if as per order, your tax demand is 10 lakh, whether pre-deposit of 1 lakh is there or not. As it is an appellate tribunal, it will become 2 lakhs. So they will verify all those things. Even they will also verify that the paper which you have given is readable or not. Suppose the document which you have given, xerox are not proper, it is torn, then he will immediately give you back that appeal. He will not take that appeal. He will not take it as submit. He will ask you, go get the change, get it changed, and then you come with the new set. Suppose if few things, he took the document, after taking the document, he came to notice few things has been missed out. Then they issue a defect memo. While in defect memo, they specified what are the problems they notice in the appeal set submitted by you. And they will give you some time. Normally in SysTat, they give you 7 days. Here they are saying 7 days. Normally 6 days, they give 15 days. Here they are saying 7 days plus additional 30 days. So they give you that timeline. With that timeline, you can go either in the already submitted appeal, you can change the relevant page, or you can submit a new set of appeal with removing all those defects which has been noticed. Now, as he also said that with pre-deposit, there is also appeal filing fee. That also he will verify whether paid or not, properly paid, in the name, those all checking happen. This is what the proceeding which is there even for GST also. So here also they will issue me at the time of when I went for submission, there only if they will check. If something has been missed out, it will be again be checked by registrar, and they will issue a defect memo, and we will be given a time to rectify that defect. If we don't rectify that defect, then it is upon registrar. This is registrar power to decide. He can say he may not admit my appeal, and he will write basically a letter. He will write that I'm not admitting the appeal. You submit a fresh set. Or if I give any reason that why I was not able to rectify that defect, then he can post it for hearing, where tribunal will decide, because tribunal has been given a power. They can give me an exemption for certain document which is specified for submission, if not submitted, based on sufficient cause been shown. So this is how the defect and admission of appeal will work. Now coming to pre-deposit part, he talked about that. Now over here, the circular 224 relevance is from the fact that tribunal is not formed. Payment will happen to GSET portal, which is there but not operational. Portal is there. You can go to website, but it's not working. Means functions has not started. Now, as we know that till the tribunal is formed, there are cases where the department has issued us a recovery notices. Even though tribunal is not formed, as they are saying earlier, there it was mentioned only 3 months from date of communication of order. Afterward, the government has changed it from the date to be notified. So department were initiating recovery proceeding, even though it is a beyond control circumstance, because tribunal is not formed. So how I will go for appeal? So they came up with a circular as an interim relief, where they are saying will not initiate recovery proceeding. They are barring department to initiate recovery proceeding, provided we make the pre-deposit which is required for the appellate tribunal. So 10 plus 10. Now this 10 is also still not notified. As of now, today date, it is 20% pre-deposit, not 10%. In the law they have given, but that law has not been notified. These are these are going to become as a changes. Even the penalty amount. Now there can be a case where issue is only of penalty, or it is an issue of tax, interest and penalty, but you are contesting only penalty. As per law which is existing, there is no pre-deposit, but they have proposed if it is only penalty issue which has been contested, then you have to pay 10% of the penalty also, like section 129, where it's only a penalty issue e-way bill. There can be a case of 73 or 74 also, where you might have paid the tax interest, but you don't want to contest the penalty. So then 10% of the penalty you have to deposit. But these are not applicable as of now. There is no pre-deposit for penalty case currently, and it is 20%, not 10%. These are all proposed, which are going to be changed. So in order to make sure recovery is not made by the department, this interim circular is basically working, where they said you may pay the payment which is made to be done for pre-deposit, and you give one letter in writing saying that against this appellate authority order, you are planning to file an appeal, and based on this appeal, you have made the pre-deposit of 20%. For time being, it is 20% of the disputed tax. So they will not they will not initiate recovery proceeding. And this you have to do in all the cases where appellate authority order you have got and you have not done. Now the question which arises, how should I do the payment? Through DRC 03, or there is other mechanism? So they have also come up with this. They are saying you have to go to the portal, service, ledger, payment toward demand. And through that option, you have to do your 20% pre-deposit. However, there can be a case that few SSC, because of those recovery proceeding, went to High Court. High Court said you make 10%, 20% pre-deposit, they will not do any recovery. I am giving you stay. Few of the SSC would have made the payment of pre-deposit through DRC 03. So they have come up with the concept of 3A, where DRC 03 can be linked with the order against which payment has been made, means pre-deposit has been made. Again, you will link it, and again, you have to write a letter to the judicial officer, recovery officer, stating that not to initiate, as I have done the compliance of circular 224. If you have not done, officer is well within the power to initiate the recovery proceeding, and it is specifically mentioned in this circular. Continue, Jagadeesh.
So in many cases, department has started recovery proceedings against the appeal order. So in order to stay those proceedings, department itself is insisting to make the pre-deposit for who are intending to file an appeal before the appellate tribunal. So for that reason, department itself, they are insisting to pay that pre-deposit amount through DRC 03. So this we can set off later through DRC 03 against the demand created. So this is what the circular or 224 is saying. So now coming to the hearing and rectification thing. So hearing, as Ashika said that the entire proceedings, appellate tribunal proceedings are only through online. I mean, you can opt the hearing either through physical or through virtual mode also. That it's the option will be given by the tribunal on your request. And that coming to the adjournments, as like the first appellate or at the time of adjudication proceedings, maximum 3 adjournments are allowed. Similarly, in the tribunal also, maximum 3 adjournments will be allowed, and the reason for each adjournment must be recorded in writing. Without your request, they will not give any adjournment. All the requests should be in writing. And the time limit, coming to the time limit, within what time the appeal should be disposed. So here in the procedure, it has given that appeal to be decided within 1 year from the filing as far as possible. So this is a welcome move. And coming to the rectification of the tribunal order. So within 3 months of the order date, you can file a rectification order, like similar the case with the original order or the appellate order, and provided that no amendment which has the effect of enhancing an assessment. I mean, the demand is created for 10 lakh. On rectification, if it is increasing of 15 lakh, in that case, without giving an opportunity of being heard, it cannot be enhanced. The similar the case with decreasing the refund amount or the denying the input tax credit. That is which are creating an adverse effect on the taxpayer. In that case, they have to give an opportunity of being heard, then only they can rectify it. So who can be the authorized representative? So GST appellate tribunal procedures has provided the person who can be act as an authorized representatives. Now we'll see who are all they. Relative or regular employee of the taxpayer, or the practicing advocate, or the practicing chartered accountant, or the cost accountant, or the company secretary can act as an authorized representative. And also the retired tax officer, provided his ranking should be above Group B or above, and the GST practitioner registered under Rule 83 of CGST rules. So all these persons can act as an authorized representative of the taxpayer, provided if there is any disqualification due to dismissal or removed from the government service or convicted of fraud or undischarged insolvent and guilty of professional misconduct. If he disqualified due to of any of this reason, then he cannot act as an authorized representative of the taxpayer. So coming to the dress code, appellate tribunal is very particular about this dress code and decorum. For the legal practitioners, their dress code has to maintain as per the applicable bar council rules. For the practicing professionals, I mean CA, CMA, CS, they have to maintain the formal letter as per their professional bodies, ICAI, ICMA, and ICSA. And coming to the others, other than legal practitioners and professionals, they have to maintain the formal letter. Yeah, it should be the formal dressing. They have to be for maintain the formal dress code and all that thing. Coming to the decorum, they have to maintain a decorum. That means there should not be no interruption. They should not raise voice against the tribunal members or disrespect any of the member. If they notice any of this thing, they will treat this as a serious misconduct. They may depart or can give a serious warning to the uh, other representatives. So coming to next, yes, yes. What do you mean?
So tribunal order. Now we understood the bench.
I think as far as the dress code, I want to just highlight the fact that there are two places this dress code is discussed about. In one place, they do say this. In another place, they do specifically says if the professional bodies have not defined, it shall be close collared black coat. Like similar to probably what I'm wearing with a full sleeve of a black, or white shirt with a black tie, open coat, which is what we presently follow when we appear before the tribunal. This is for the male members. As far as the female members also, there is a specific mention that it's a sari or a white dress, or on that there should be a black coat. So this is generally what is presently being followed in tribunal. That is what is also prescribed in this particular rules as well. Okay. So Ashika madam, when she goes to tribunal, what they should be wearing, she knows. Similarly, practically we have to see, we may get different color ties. It's very difficult to get a black tie. So generally, we try to get those things, and we generally used to keep in a bar that is where the association room, so that anybody comes, they can use a black tie from outside. So just telling anybody who wants to appear as a judge, just be prepared that you have a black coat on a white shirt with a black tie on. Okay. Yeah. Ashika, you can proceed to the next.
So we learn about the benches, we learn about what will be their territorial subject matter jurisdiction and what appeals forms to be filed, and while filing the appeal forms, what format and document to be submitted. Now coming to the part of tribunal order. Now, one order is the final order, where they hear the case on merit and finally decide whether they are allowing the appeal or they are not allowing us the appeal. So it can be also a case, part appeal may be allowed also, means where there are multiple issue, few issue tribunal may allow, they may confirm the demand. But there are also various other types of the order which based on the application filed by us is passed by the tribunal. Jagadeesh, next. So final order, as I said you, it's a conclusion of the appeal file. Now, we have been also given an option to file interlocutory application. What is this interlocutory application is? Sometime we have to file miscellaneous application. Like if we have filed an appeal after the due date, but within the extended time limit, that is condonation of delay, in short, COD. So if we have filed that miscellaneous application and based on the cause, we have shown that why we were not able to file within the first due date, By hearing that, the tribunal will pass interim order. So this is what interlocutory order it is, where they can, by allowing me my condonation of delay, accept the appeal. Another type, if you will notice, at the end of the table in italic, there are various types of application we do for early hearing, for like some documents to be produced, but we cannot produce. So we can ask for some extension of time. So various applications we do. Based on those miscellaneous application, this order is passed. Then ex parte order. This I have already discussed. Like if the party appellant does not appear, if the appellant does not appear even after giving repeated opportunity, then the tribunal, based on the record available, can go ahead and pass the ex parte order. Ex parte order will be speaking order. Speaking order means where the issue wise, case wise, all the points will be discussed based on appeal file, and it will be properly concluded that on this issue, this is they observe, on this issue, this is what they are allowing, this issue not allowing, not allowing, why it is also not allowed, and allowed, that also will be specified. And at the end, will be written that appeal is partly allowed, disposed of, order is set aside, whatever may be the situation. Ex parte means basically appellant did not appear. So based on the data or record available, this order has been passed. Rectification order. Now, in the where the order passed, there may be a case that there may be some error. Now, over here, error is limited to mistake apparent on record. Means tribunal can't redecide the case. Only like arithmetical error, or there is some section or rules wrongly mentioned. Those type of error can be corrected, and accordingly rectify order can be passed. If you notice, Jagadeesh previously only discussed about rectification of order. He discussed about the time limits also. So if you notice there is some mistake, you can get the order rectified. Then restoration of order. Now this restoration is linked to ex parte order. But this ex parte order will be limited to where appeal without deciding on merit has just been dismissed on account of non-presence. Ex parte speaking order cannot be restored. Only ex parte dismiss on ground of appeal, means where they have not gone into merit, they didn't decided anything, just they are saying I am dismissing this appeal on account of non-presence of the appellant. In those situations, as an appellant, we can go and apply for restoration of appeal. And if they are satisfied with the ground present, the tribunal will pass the restoration order. Another is cost order. Cost order is where just appeal has been filed, which wastes the time of the tribunal, or with has been filed with fraudulent intent, or to somehow misguide the tribunal. In those cases, tribunal has been given a power that they can also impose the cost for the time and energy which has gone into this case. So thereby, this is called cost order. Next. Now, I said when the case is decided, they will pass one final order. Now, order can be to confirm the demand, means they are agreeing, they might be agreeing for full order, they might be agreeing for part order. Situation can be anything. It can be modified, means demand may be confirmed for 10, they are saying you are liable to pay 2 lakhs. It can be either to annul the order, fully setting aside the order, or it can be a case of remand back. Remand back means where you have produced certain documents, certain facts which has not been considered by adjudication officer or appellate authority while passing the order. In such situation, tribunal has the power, it can ask for either fresh adjudication, means nothing has been concerned, means your reply, even like we have seen, due to time limit, order has been passed without discussing anything on the reply submitted. Simply lining one line, I am not satisfied by the reply submitted. This types of order can be remanded back by tribunal for fresh adjudication. So to consider the reply with all the relevant documents submitted by the appellant. So this is called fresh adjudication. One is where, suppose like undertaking under circular 183, like 2A versus 3B, we have seen that even though not appearing in 2A, they said you submit a undertaking or declaration from supplier that they have paid the tax, I will allow. So suppose one of the party you could not produce previously, now you have, so they can ask to remand back to that extent. Key only just check if it is in compliance, then allow it, otherwise confirm. So remand back can be for overall full process to be checked. When fresh adjudication happened, it means it starts from show cause notice. Fully they will verify. It can also start from order also. So it depend upon level to level, which will be decided by tribunal. Or it can be also limited that only check this quantum. Other things they would have decided only this based on what direction tribunal has given, it will be decided, and accordingly to limited extent that order will be passed. So this, I will ask Rajesh sir to put the thought of that evidence and grounds. Rajesh sir.
Sorry, can you just repeat?
So that evidence part and ground part.
There is a evidence which is there. There are a lot of, generally when we deal with the tax litigation, the process which we follow is a sort of a summary proceedings, not a evidence-based proceedings. In other words, in an evidence-based proceedings, there will be a examination of witnesses, there will be a cross-examination of witnesses, evidences, and then comes an argument, then come a final decision. Here it is not like that. However, in appropriate cases, powers have been given to the appellate authority as well as the tribunal to call for an evidence or documents or witnesses to check the facts or to decide some issues. Tribunal being the last fact-finding authority, they have to be given all this power of examining witnesses, summoning, etc. One important point we need to note, any evidence which is to be produced before the appellate authority or the tribunal should be the such evidence which has already been produced at the adjudication authority. You are not permitted to produce any evidence which was not produced at the stage of adjudication. You can do only in an exceptional circumstances, one where you are prevented from producing that, or the authority did not permit you to produce, or there was valid reason why you could not produce it. So in this reason, they can consider any new evidence. Any new evidence which you place before the authority, what the tribunal is required to do, they are supposed to write a reason why they are admitting this evidence. Second, after having admitted any new evidence on record, they are supposed to give an opportunity to the other party to examine that particular evidence or witnesses and bring in a counter evidence or counter witnesses against the same, and also cross-examine a witness if any we have produced. So these are some things which are technically which we need to be aware, which becomes important in cases where the appeals can be, some documents you produce at the appellate stage can be rejected because it was not produced earlier. So it becomes important that in the reply to notice, in the adjudication stage, we are required to produce all the documentary evidence and other evidences which are required, which you want to use it to prove your case. When it comes to the grounds of appeal, you are not supposed to argue any grounds of appeal which are not put across by you in the grounds of appeal, unless tribunal permits you to argue that particular matter. So these are the some points which you need to know as regards to the additional evidence or additional grounds of appeal, which you can take up at appellate stage, which you have not taken in earlier stage. There's a difference between a ground taking in the appeal memorandum and a ground arguing which was not taken in the appeal memorandum. Please note, though you would have not taken some grounds of appeal in the earlier stages, which is of a technical, legal in nature, you are still permitted to take such grounds of appeal in the appeal memorandum. There is no bar. However, if you are not put across grounds of appeal in the appeal memorandum, but you want to argue that grounds in the tribunal, then the tribunal has to permit you to take that grounds of appeal, or at least file an application for adding the grounds, and that tribunal has to accept. So this is something which you be aware of if you are handling a litigation. Ashika, you can proceed.
Next. One more thing is about difference in opinion. Like in the initial starting, we talk about single member bench, double member bench. So in case of double member bench, there can be a case one judge may agree that this is the correct way of reading. One judge may say that it agree with you. Okay. So if that scenario arises where there is a difference, one agreeing, one not agreeing, in that scenario, it is said that it will be referred to another member of the same state bench. Okay, within that state bench, like sir told, in Karnataka, there will be 2 state benches, plan is. So either it can be referred to that another state bench members, or if another member within that state bench is there, it will be referred. And based on majority of the opinion, means because it will become 3, another member which is referred. So 2 whose majority will be there, based on that, it will be decided. But it can also be a case there is no other. Like in Karnataka, there may be 2 state benches, but in other state, it may be 1. And that 1 state bench also don't have any other member available. Then it is said that in case of this difference in opinion, it will be transferred to another state. Earlier, it was within state. First, availability will be checked within state. If within state is not available, then another state to decide on the issue where there are difference. Means one is saying yes, another is saying no. Similarly, for principal bench also, it will be first referred to another member of the principal bench. Or if that is not there, not available, then it will be referred to any of the member of the state bench. Now, so based on the majority of the opinion, it will be decided. But over here, if we see that it is said that it will be referred to another member of principal bench or state bench. But if we will see the GSET rule, it is talking about if there is a difference between the opinion of the members of bench, it will be referred to larger bench. Okay. So Act is saying that how it to be done within state, within principle, not available, then other state based on majority. But when it comes to rule, it is talking about it should be referred to the larger bench. So here there is little distinction, the way the thing is prescribed in Act and the way the thing is prescribed under the rule.
Ashika, can you just go? Okay. There is generally what happens. I want to explain the concept of reference to third bench and reference to larger bench. When it comes to reference to third bench, third member, now I am sitting and deciding a certain matter, and there's another member who is also sitting and deciding the matter. While hearing the matter, there's a difference of opinion of a members of the same bench. then it is called as a difference in opinion reference to a third member, which is dealt in section 111 subsection 3. Whereas reference to a larger bench in the context in which it is referred, though I think it requires a little more clarity, is this. So there is a decision which has been taken by, say, Karnataka State Bench, saying that on, say, for example, the what CSM activity ITC is eligible. On the other hand, there is another state bench has taken an opinion, taken a stand, saying that it is not eligible. Now the matter is being heard by subsequent some other bench, or in that particular bench next one different case. Then now the question will come. Now there are two conflicting decisions which are there. Which decision to follow? Then in such case, the matter is supposed to be referred to the third member, not third member, to a larger bench where 3 members will be constituted, 4 members will be constituted, sitting in one bench, and they will decide the matter, and that is called as a larger bench decision constitution. Constitute larger bench and decision by larger bench. I think harmoniously read, we have to read that and this in this manner. Okay. Right. Ashika, any other things? Did we come to a closure part? Or any more things are there? Jagadeesh, anything else is there?
Only procedures are there, sir, but I will give you an overview. I will complete in 2 to 3 minutes.
Yeah, please.
Yes. These are the new rules. In addition to CGST rules 2017, GST Appellate Tribunal itself has prescribed these rules called the Procedural Rules 2025. So Section 111 has given the power to issue the rules by itself. So by virtue of it, Section 111, by way of notification 217, they have issued the Procedural Rules 2025. So total 124 rules have been prescribed under this, which are divided into 15 parts, 15 chapters. So if you can, most of these rules we have already discussed in today's session regarding the powers, time limits, hearing, record of proceedings, and appearance of authorized representative. So most of all these rules we have discussed in today's session. So I have not going in detail about all these rules. So similarly, they have given the forms. They have prescribed forms also. Total 8 forms they have prescribed from the form 1 to the form 8. So in this form, we have to make an application to the appellate tribunal, or how we have to follow the procedures, all that thing they have prescribed on all these forms. So we have to follow. I have similar the case with the now coming to the so yes. Now coming to the GST fee. So filing of appeal, as we discussed in the previous slides, that for filing an appeal also there is a fee. So what is the fee for that? So for every 1 lakh of disputed amount of tax, ITC or fine, the fee would be 1,000. Let's say the demand amount is a 50 lakh. So 50 lakh, 50,000. So in that case, you have to pay the appellate filing fee of 50,000. But there is a maximum cap. That is maximum amount you have to pay 25,000 and minimum is 5,000. So if your demand amount is 4 lakh, then you need to pay a minimum filing fee of 5,000. So this is the fee they have prescribed in the Rule 110 of CGST Act, CGST rules. And coming to the interlocutory application, that means if you want to file an application for condonation or interim relief and stay, in all these cases, for each application, the fee would be 5,000 per application. And similar the case with the application for inspection and any other provision specifically not mentioned, for that also, for any other application, miscellaneous application, for that also the 5,000 is prescribed. And for getting certified copies of orders or documents, further they have prescribed a fee of 5 rupees per page. This is the fee they have prescribed. Whereas for the rectification of errors, there is no specific fees have been prescribed. And for the petition or application for the department authorities, there is no fee for the department. So this is all about the fee, tribunal fees. And the coming all fees are payable to the GST Appellate Tribunal portal, not from the general portal what we are using to file our GST returns or refunds. For that, there is a separate portal called gst80.gov.in. Even the application for tribunal have to file through only through that portal. And coming to the late fee or penalties for delayed payment are not specified, but standard GST rules may apply. That is, general CGST rules will apply. No, there is no nowhere specified in the GST 80 rules. So this is about the fees, and these are the registers which are need to be maintained by the registrar, not by us. So if you see the CDR4, this is the appeal register, and 59C introductory appeals and inspection appeal registered. All these registered are required to be maintained by the department, not by us. So there is no such importance to refer these registers. So that's it. Yeah. Any questions you can ask, or you can put your questions in the chat box.
I think,
Yes, sir. What do you say?
Jagadeesh, thanks, Ashika. Ashika, the question, one of the question is, by what time GStat is expected to function? You have to answer.
Sir, I don't know.
No, you should tell something. You can tell 6 months, you can tell 1 year, whatever it's fine, because it is going to happen whenever it happens. Merely by saying something that we say something doesn't mean that it's going to happen. But what we expect is probably by 1st of October it should be functional. At least the principal bench or the portal at least would become functional, what we are expecting. But we have to wait and see. I think Mr. Aravindan has, whether appeal has to be filed within 3 months of the constitution of the state. The actually the 3 months time limit is from the date which they will notify, where as on date no dates have been notified yet. Probably once the tribunal starts functioning, they will come out and say, okay, this is the notified date for this purpose. Under 112.1. Once such notification is issued, it may be say 1st October, then we will have 3 months time from 1st October. And further condonation of delay period will be further 3 months from that particular after completion of the 3 months. So this is how the thing. And who knows, first they may come, still there will be technical hiccups, then they will come back and again amend the notification itself. We'll have to wait and see what is going to happen. Yeah. Any other questions? I think feedback forms. Okay, do we have to submit hard copies to the appellate tribunal as we do before the appellate court? As per the procedure, there is no requirement of filing any hard copies. We are only required to file soft copies, file online. In case where the orders are not uploaded in the portal, that physical copy of that order duly certified needs to be filed either online you need to upload or physically within 7 days of filing your online appeal. So that will be critical for you to consider when your appeal is deemed to have been filed. So in that context, it is important that when your orders are not uploaded online, that's APL 4, which will enable you to file the appeal online, then you may have to file appeal online, but order you may have to again sign and file online or physical within 7 days. There's another question. Can 10% pre-deposit be paid using the credit ledger? In fact, yes, there was circular to the effect. In fact, this issue was there. There was objection in few high courts, And later on, recently, the Supreme Court has confirmed the view that such pre-deposit can be made utilizing the credit ledger as well. There is another question, sir. Have you find any significant difference in CSTAT and GSTAT? The way, I mean, we have yet to see the admission factors, because procedurally, I see there's a little difference because there's no admission factor in the earlier thing, but there's an admission factor which is coming in the GST law. Another difference which I am seeing is in the rest by law, the people who are carrying out the proceedings were judicial, I mean, the members were having a different style of operation, but with the new people who are basically coming from the court background, I think the way they are going to conduct the proceedings will be more tilted towards the court type of proceedings rather than the present stat type of proceedings. I mean, this is only my wild guess or expectation, but we have to wait and see when it starts, whether we will drive them back to such a type of operations or they will drive us to their operation of court type of proceedings. Yeah, I think that's all I think. Thank you. Ashika, would like to add anything or tell anything? Jagadeesh? Otherwise, I think feedback sheets will be sent. I think you please fill up the feedback sheets. I think our people will be sending you the PPTs if you request only upon filing of feedback forms, because we need a feedback specifically. So after this session, continue this session. I think Delhi Babu is going to take up a technical session as a part of this program. Meanwhile, if Ashika is going to tell anything, she will tell. Otherwise, she's going to conclude.
So just one thing, today's purpose of session was just to lay down base work for the GST Appellate Tribunal, which is going to come. So our focus was more towards that, instead of going through each and every rules or every provisions, how it to be done, what you should do. So today we just lay down the ground, but in future, obviously, we are going to come up with the various session on this appellate tribunal itself also, where we'll be taking you in depth, what you need to do, how you need to do, while filing form, what steps you should do, when hearing will happen, what care you should do, while replying to appeal also, drafting grounds of appeal, statement of facts, what are the precaution and how you should write. Those all also will do, but with the time. That's all from my side, sir.
Thank you, Jagadeesh. Thank you. Thank you. Over to you, Delhi Babu.
Yeah, thank you, sir. Yeah, very beautiful session done by you, sir. It's more useful to users. Yeah, thank you, sir.
Thank you. Good. Thank you.
Hi all, good evening once again. The second part of is tech updates. Here we have Append analyze data for dynamic reports. The second topic, month-wise trial balance from multiple companies. The third topic is let formula to simplify complex calculations. The fourth topic, auto posting AR from Tally to Google Sheet. Yeah, quickly, if I want to tell why we have taken these four topics. Number one, merge append. This is more powerful modules in Tally. In Excel. Why I'll tell you. This all four topics will help to accountants, business owners, data analysts, and auditors. Audit who is doing bank audits and data audits or system audits. I'll tell you one small example. Whenever we are doing bank audits or accountants when they're doing bank statement accounting, most of the time, most of the banks, they will give quarterly statement or monthly statement, or they will give you separate files. During that time, because we also have the same kind of experience. Most of the time, the team will do, they will try to find out macros for consolidating that multiple files. Otherwise, they will try to find online tools to consolidate that multiple files or statements. Instead of that, within your system, if your updated system updated Excels to 2016 or 19 or 21 or Office 365, these are all features are available. Otherwise, if you are below that versions, you can download. There is a plugin for Power Query editors. Using that one, you can work just 1, 2, 3, maximum 3 or 4 steps. You can merge your data or append your data. You will get the summarized data using that functions. This will help a lot for who is working on data or multiple files consolidations or merging. Okay, we'll go to the practical session. Another important one for this same zone for accountants or auditors or who is doing the data analysis. Let formula also will help a lot from who is using Excels. And month-wise trial balance. There may be, most of the time, if you want to do monthly analysis, if you want to extract trial balance month-wise, you can go and there is a function in your front end. You can convert into month-wise and export it. Or if you have multiple companies, again you have to export each company wise, month wise, then you have to do some formatting, all those things. If you just apply few methods and if you create one small template using Power Query, click up button, you can extract. If you have number of more than maybe okay number of companies data, click up button maximum based on that volume of data, you will get that month wise summaries. Then the final one, auto pushing of AR or AP, Tally to Google Sheet. In Tally, there are many limitations, but most of the persons are using Tally, as you know, for accounting purpose in India, maybe in others also. For them, they want to follow AR. There is a limitation. If they want to give access Tally to outside their field persons, there is a limitation. They can't able to give. Now the Tally has given browser option, but there is also a limitation. Your Tally has to be open, internet has to be proper. But if you use Google Sheets or SharePoints or any other cloud applications, Tally has post and get methods, API methods. You can use that method and you can post the data to Google Sheets. From Google Sheets, you can share that link to your field persons or whatever, whoever is responsible persons. They can easily access and they can use the data and they can go and discuss with their clients. Or if management want to see the age-wise reports, whatever, then using that sheets, whenever they are in suppose in travel also, they can open and check that outstanding age, whatever reports they want. This kind of there is a more useful things who are using Tally for Google Sheets. Okay, we'll directly go to practical sessions, how we can use multiple files, merge or append, how we can use for dynamic reports using these two modules. Okay, here I have some sample data of Bangalore, Delhi, Goa, Hyderabad, Mumbai for April month. This is simple sales data only. Just I wanted to convey how this functionality is working. You can apply the same methods in your data. See here I'm having Bangalore sales with date, invoice number, product code, customer. Here there is no description. We don't know food 10124 means that name we don't know. Okay, anyhow we'll work on it. Then quantity, rate, discount percentage, value, salesman, commission values. With the same format, there are multiple locations. We received this one. Now, just I'm giving an example. We want to account it, other we want to create one report for analysis. If you want to merge this one, there are multiple methods as I told. You can use online methods or Excels or any macros. You can just execute that, it will come. But using, sorry, any questions?
ఓకే మేము ఇంకా యజమానికి వచ్చేస్తున్నాం అంటే యాక్చువల్గా 6 కల్లా బయలుదేరుతాం కానీ మేము 39 కల్లా వచ్చేదాన్ని.
Is my voice is audible? Can you put in chat?
Yes, sir.
Is my voice is audible? Can you put it in chat? Yeah, great. Thank you. Okay, using Excel only, we can merge, we can append this data. First step is there are multiple files. We'll load that multiple files into Excel Power Query. There is a Excel additional module Power Query. We'll load into the Power Query. Then we'll try to merge all the files. Merge or append. That there is a difference between merge and append. Append means it will take the files and add one below one. Merge means it's similar like VLOOKUP. I'll show you one by one. First, we'll work for append. Here in Excel, go to data and get data. From get data, there is an option from file. Using this from file, you just from folder. We'll give you this path. See, this extracted all the files from that folder. We'll transform. We just transform as it is to Power Query editor. Here is the path for our reference purpose. There are multiple methods we can use. Just I'm showing you one of the method. If you are okay, here we have that all the XMLs. You can here you can able to see this is the file for Bangalore, Delhi. Okay, anyhow we'll use this column. We'll remove other columns and we'll try to add one column from binary to we'll convert it to Excel. Yeah, before this we'll just check all files are same or different files are there. Yeah, see here product file is there. We don't require product file. We'll remove that one. Then we'll remove all other columns. Here we'll try to add one additional column to convert to table. For that there is a function excel.workbook. Here it is asking workbook as a binary. Yeah, see in content column we have binary. Yeah, there is a list time. I'll try to cover all the subjects. I'll be little bit fast. Wherever you're having questions, you just let me know. Yeah, it just binary to table is converted. We'll expand this one. See here we have a data. If you press in table, you can able to see all our data. Other than this, we'll remove. Just if you follow a few steps, you will get consolidated reports. See here, I'm just expanding it. This is expanded. Now we'll use first row as header. Please share the video. Definitely we'll share recording and also we'll share the sample templates. See now all branches data consolidated into one table. Now we'll load into Excel. Here I'll tell you the Power Query is more powerful function, powerful module. You can work with a large set of data also. That time you will have to check one thing, your system RAM, a memory, a process, it is in at least minimum minimum memories are there or not, then only it will work. Otherwise, it won't work with large set of data. Yes, now we just applying few steps and we converted, we just appended data into one sheet. This is called we append. There are multiple methods we can apply for appending this data. This is one simple method you can append. Here, if you see the Bangalore data is added and also Delhi data also is added. Then Goa, Hyderabad, all branches data has came. Now we'll try to match product description. Okay, for that one also again we have to extract. Here I am just using Excel workbook module. I'll tell you why. Here I am only extracting product master. In product master we will have code and description, all those things. Using this function we can convert it to table. It will read from that file and it will convert it to table. See, here I have product code, product description, category. I'm just transforming it to PowerPoint editor. This will help a lot to who is working on data sets or doing audits or accountants. It will help a lot. And also sometimes business owners also, they want to review on large data sets, they can apply this methods. So this is my master data. Here also having first row headers. We'll just use first row as header. It will convert to headers. Then we'll go to the Excel files, the consolidated table. We'll try to use merge. Here if you see there is append, there is a merge. We'll use merge query as a new query. That means we can able to understand how it is working. My first table is Excel files. My second table is master data. It will work like VLOOKUP. See here I may have a product code. Here I may have a product code. You just select it. Then automatically it will show the matching results. Out of 224 rows, 220 is matching. You just click OK. Yeah, merge data with product description. You just expand this one. Don't require product code. So this is how we can use merge and append queries. We can consolidate data, we can merge data, we can use for our analysis. Second, it is loading. Yeah, it's loaded. Maybe the data is converted into number. Okay, we'll convert it to date using Control Shift 3. See, now we have product code along with product description and category. Now you can apply pivots and analyze your data. Branch wise sales. Sorry. This is your branch wise sales for April month. Same to same, if you want to see salesman wise or any other methods, you can apply using pivot. Now you have a data in your hand, consolidated data. Because of limited time, I'm just showing one small example only. Okay, very good question. They're asking when we are merging the data, the header should be the same. No, not required. Maybe if you can give the reference of that column, that we'll consider. No need to be in the same matching names of the headers. it will be based on column references. Okay, any doubts until here? We did consolidation of all the files. We did merged with product codes we used for reporting purpose. You can apply with your data for various reporting purpose. Now we have clear-cut data with okay for all the branches. This is about append and merge. Okay, now we'll go to just closing this one, not saving. The second topic, month-wise trial balance for multiple companies. Yeah, this is very beautiful thing. Quickly I'll show you. So I do. Sample data of 3 companies. You can select the headers from the each of the file to master example. Yes, yes. It's just because based on the column references, it may not consider headers. Here I have 3 companies. Let me open 2 companies. Okay, first we'll try to sync with one company data. I will show you how this will work and the steps also. The result I'll show you how the result will come. Yeah. Just setting period from April to April 25. Okay, then we'll go to Excel. This is the template. We'll guide you how to create this template also. We'll show you the steps. Number 1, the port need to be checked. The port will be here. Sorry, settings, connectivity, configuration and server configuration. Here you need to set that port. Otherwise, if there is a different port, you will have to update same port into your Excel. Then only it will connect directly to your Tally. The second thing, you'll have to give that month list of months. Then based on that, it will extract for that month's trial balance. Then the third step here, I'm just added steps, step 1, step 2, step 3. Here you just select in this cell and refresh it. The active company list name will come to this place. Based on this name only, the data will extract from Tally to Excel. Maximum less than minute, it will extract data. See, it's extract that active company name. Then finally refresh. Again for refresh also for 1 year, 2 years also, maximum less than a minute, it will extract the data. You can observe below the screen, the query is running background query. Until that query running is in process, the data is extracting and processing. You have to wait until that status is ready. Yeah, it's done. See, now it's showing ready. Now we'll come to trial balance. Here if you see April to April, the data has extracted 2487 GLs are there. Here one more thing, you can able to see the company name and also the nature of group. Is it asset or liability, expense, income, and also the GL name, parent group, primary group, and month-wise data. Using this data, you can use it for your monthly MIS or analysis. Whatever reports is required, you can generate reports using these reports. But quickly, I'll show you how we can connect it to Tally and how we can generate this report. Maximum within 5 minutes, I'll show you. I don't need to take more than 5 minutes. I'll show you the steps. Then we'll share this file with you. Maybe you also can easily construct based on your requirements. This is one simple code. Maybe if you go in Tally help document, if you search in Google or in Tally website, they will provide you basic SQL codes and how you can extract from third-party applications. Using that one, you can construct a reports. Here I'm just opening Excel file. We also just taken the same codes only from Tally websites. They will give you sample only. Based on your requirement, you will have to convert that. Yeah, very good question. No need to, there is no need of any additional features. It's inbuilt feature only. Power Code Editor, it is available from 2007 version. 2007 and 10, you will have to get one additional plugin. From 2013 onwards, by default, they provided in Excel. Data within data, you will get that Power Code Editor options. Launch Power Code Editors. Otherwise, there is an option. They will give you add-ons. I'll show you here in developer. You can able to see this kind of add-ons they will provide in their website in Windows. Search in Google. You can download and enable that plugin for below versions of Excels. That will work as same only. Here we'll go and okay. Now just I'll show you how to connect multiple companies step by step. We'll go to Power Code Editor first. We'll try to extract at least Ledger Master. I'll show you Ledger Master only because we have less time. From one company and multiple companies, how we can just I'll show that methods. Using that methods, you can apply for your requirements. See, this is Power Code Editor is coming with empty. Here in left side, you can create new blank query using new query and other queries in blank query. This is one way. Otherwise, from home tab, new sources, other sources, blank query. You click on it, one blank query will come. In the home tab only, you will get advanced editors. Here we can write is a M code only, Microsoft code. I already just constructed that one for our training purpose. Here also I'll show you. This is the Tally accepted format. Tally always will accept XML only. It won't accept other formats. I'll show you how this code is. See, this is the Tally accept format, accepting format. Okay, now I'm not going to explain these methods how it is. Maybe if you follow their website, you will get this kind of samples. Based on that, we can extract. Same way, I just convert it into M code format. You can use ChatGPT or Gemini or DeepSeek, whatever AI tools you are using. If you give this XML structure into that and ask ChatGPT to convert into Power Query, that will convert, or M code, you can say M code also, that will understand, that will convert and give it to you in the same format. Using the same code, just click on it. It will extract ledger master from current company. See here it is giving error. Could not set SV current company. SV current company is not same in my input. We'll just take this name. We'll go to again into Power Query. Here I given only ABC company limited. It's not matched in current active list. That's why it's giving error. I just replaced it. Yeah, it's extracted. See here one empty row is coming and error is coming. There are many functions in UI itself. You can use it. See here, remove errors, remove blank rows. Okay. By default, if you extract from third-party application, there will be some UTF-16 headers that will give us the error. That you can remove, no issue. Maybe if you practice 1 or 2 times, you will understand. Now we got the current active company ledger master. Now I'll try to load another company, whether it will fetch or not. Company 1 is there, company 2. There is a huge master list in both the companies. I'll show you that also. See, there is 3,400 masters. Okay, anyhow, there is a two companies. Here we hard coded C1 company, company one. Now it will extract, if you refresh multiple time also, it will extract that C1 data only. It won't extract other companies. Now how to do? It's very simple method. There are many functions in the list dot accumulate, gist dot get. There are functions, looping functions. You can use that and extract it. But that is, if you want to use that function, you will have to have more knowledge on M code. Just overriding that, giving one small idea, one workaround method is very simple method. Unskilled person also can use and extract multiple companies. Now I'm going to show you that method. Here we'll create one more blank query, or else we'll go directly to ODBC. No need to write that code also. It's user friendly function only. You can select tally ODBC. Here you just write one small code, select it. This select code is also available in tally help. Again, we will share you this along with recording this all the codes from company. Company means it's a table. Company is one table, ledger is one table, unit of measurement is one table in tally. Vouchers also is one table in tally. Here from companies table, I'm just extracting names. Using what is, I didn't write any M script. Just I just used UA functions only. See, my query 3 has extracted list of companies. Anybody have any questions until now? Any doubts, any clarifications? My idea is to get first list of companies, what are all active companies from Tally. Then we'll apply one formula to extract company-wise ledger master. Anyhow, in query 1, we have a ledger master script. This will convert to function for masters. How to convert? Nowadays, you no need to remember these are all the things also. If you use AI tools, it will convert everything. Because I have experience on the scripts, that's why I'm writing. You don't need to write, you don't need to remember also. If you just apply your methods how you want, there are many tools to help you. Sorry. Here, okay. Company name. This is just one variable function name. Here, instead of hard coding, I'll give that variable name. It's a function. If I give that company name into this, that will go to this company list, then that will fetch that particular company ledger master. See, if I change it to, oh, sorry, I didn't specify that variable type. Company name as text. See, text is not number, is not logical input. See, here it is coming ABC. Just to give an idea, here I'll add that name. It will extract that particular company. But again, it's a limitation. It will extract only that particular company. Now I want to extract dynamically for all the list of active companies. Here using this one, I can get multiple companies. If I load here again, I'll show you. I'll select from other company, promo billing. See, if I come and refresh here, it will add promo also. Now I want to extract each company with ledger master. We'll write one additional column to extract this kind of data. By default, if you use script, there is a functions let dot accumulate, let dot get. There are other functions, but there you need, again I'm telling you, you need depth knowledge on that functions. But using this kind of workarounds, you will get same results only. very beautifully. See, I'm just created one function here with my script. Here I'm using name. Each company wise it will extract data. See, here is extracted Chroma company, ledger master. Here is extracted C1, C2. Now simply we can expand it. That's it. Here if you see all the companies are there, all companies masters also is there. You can extract same way for trial balance also. This is simple method everyone can understand. That's why I given this sample. We will share you trial balance also, the templates also with you. Maybe if you follow the steps, if you come to Power Query, if you just observe the steps, you can understand easily. It's already time over. Anyhow, try to finish in 5 minutes maximum. Another two subjects, two topics. See, now we have all companies data. Okay. Now we'll go to let formula. I'm not going to show you step to step in let formula. I'll show you how it will help. Okay, let formula is let and lambda. There are some other functions relating to macro functions, but this is very powerful functions. If you apply, for example, VLOOKUP or if functions or sum if s, count if s, that formulas if you apply on large set of data, the performance will come. If you want to refresh also, it will take sometimes processing, it will take time. But if you use these advanced functions, lambda, let, that will work real time. It won't give you any performance issues. That is number one advantage. Number two, we let formula, lambda, these are all macro functions will have a looping systems. If you apply, maybe I'll show you here how that will help. This is also just keeping mind on keeping one advantage for auditors or accountants who is doing data analysis. I'm just presenting this let formula. I'll give you one small example. If we are doing some audit and bank statements, there will be narration columns. Within the narration columns, if you want to find that exact name, that real name, it's a challenging task. If you have a large set of data, it's a challenging task. But if you create one small masters, for example, if you see in the narration in bank statement, everyone will face this issue. This will help for accountants who is accounting. Maybe if you are using Excel to tally, you can apply. Maybe I'll show you this all the steps. If you apply this method, you will get that ledger master. You can use that ledger master and import for 1 year data or 1 month data, whatever data you want. Suppose if you are doing some analysis, same method you can apply and you can get that real names. Or if you are doing some audit scrutinies, you can use these methods. Using that let formula, it will help a lot. But nowadays there is a chat GPT and there are other AI tools. There are many other functions also, that inbuilt functions only they are giving with combinations of them. But there again, there will be a performance issue. But if you use let formula, there won't be any performance issue. And also it will be dynamic function. It will generate the dynamic results. But if you use maybe index, max, offshore, there are offset, there are many functions, but there will be many limitations that functions. That is only one advantage from this one. See here, I am just showing the narration column from bank statement. There are different contents, but finding this content real names. If you see here Bajaj Finance, maybe we can easily understand terminal. For this all the contents, one-time job, if you create one master, if there is a content terminal, okay, this is the ledger name in Tally or in GL name in SAP, or is it the description for this one? If you can prepare one master, based on this, you can get that result to your statement. If you are doing bank audits, there will be multiple banks. Whenever you're doing, maybe it's month, 1 month, 2 months duration time. One time job, if you prepare this master list, if you apply that formula, you will get that exact description of that. Okay, I'll show you. Here I just created one sample format. Suppose terminal means swiping mission. If there is a cash deposit, it's a cash. Then HDB, there are some contents. These are all from narration, that the bank statement description column. This is the exact name. Okay, I just applied one small formula here. I'll just explain you a simple manner. Maybe you can easily understand. Okay. See, I just simply applied let formula and I extracted names. Maybe using VLOOKUP or XLOOKUP, you cannot able to get this kind of exact names. Maybe if you use some combination of index match and some offsets, you can extract the data using such functions, but let will help a lot. Okay, here maybe let will work. I'll show you small steps. Now this is the result using let. Maybe I can get that exact names using this content searching. Content searching. Maybe in large applications or software engines will give you this kind of results. In Excel is a bit difficult, but there are methods. But this is one of the good method. You can easily extract your exact contents. If you see, based on this, you can easily analyze the data. See how we can get this one. First, you will have to understand how this function is working. I'll show you one small example, then I'll come to again that. Here, if you see here, there is a x value, there is a y value. Within let, there will be 255. Again, in Excel, all the functions, they will give you 255 arguments. Argument means each and every one, this one. See, again, the second will enable. These are all the arguments. In let also, we'll have 255 arguments. Okay, the first argument, I'll tell you the name. Name means I'll have to give one variable. If you know a little bit of macros and any other technical knowledge or scripting knowledge, you can easily understand. X means is one variable. Here we can store the value. The name value 1. The 20. The 20, the value, the cell reference value, we can store it into X. Again, the second thing, it is asking, you want to calculate or again you want to store a name to. Yeah, I want to store name to. Why? Why the name to value is 80. Okay. Now we just created two variables and we stored that values. This way it will come multiple arguments up to 255. Here my third thing, I want to use calculation. Here simple calculation, I'll show you x plus y. Because I already stored that value into y and x. Just I'm closing this one. See, I'm getting 100. This way, maybe there are multiple methods because of the limitation of the time. I'm just skipping these are all the methods. You can use a let function. You can create multiple dashboards. It will help a lot. Okay, I'll show you just function here. Also, I just created one sample thing for dashboard purpose. Here also, I'm just storing sales value from C to C, and the selection value is E2. I'll tell you why selection value. Then function number. Here, I just wanted to calculate some value, minimum value, maximum value. Maybe using subtotal, there are options. You can use 9. Maybe anyone know basics of Excel, you can understand subtotal. If you give this one, you will get the sum value. The same way I'm using this options, insert options. These are all form controls. We call as form controls. You will get from here. You can insert it using this one for better presentation purpose. There are some other methods. You can use format controls. You can link this to this. I just given this to E1 cell here. You see here. Just if you select here, the number will come, the position number. Using that position number, here also in subtotal is required this position number. Using this number, I'm just constructing the results based on that selection using again let formula. Okay, we'll share you the sample file. Maybe you can observe it. You will understand easily. Similar way, I applied the formulas to extract this based on this bank statement descriptions, that exact names. Okay, here also I just applied very simple formulas only. First, I just created one variable name. Name means home sheet column A to A. Home sheet column A to A. This I am storing into names variable. The second thing what I'm doing is match index. Match index means maybe you know index and max previously we are using for reverse VLOOKUP purpose. How match will work? Maybe you know. Anyhow, I'll explain you. The match function will work. The first thing we'll have to give loop value, then loop array. Based on this loop value, loop array, that will give you the position where it is. Suppose if you are searching in the column, if it is finding in some position, that will give you the position number. For example, if that is finding in 9, row number 9, that will give you row number 9. Same way here also I'm finding using some other supporting functions, search. The major supporting function is search. Using search only we can able to get this kind of results. Okay, number one, here I'm using search. Within the search, I'm just adding that variable value. Within the variable, the B6, the B6 means that description. I'm just storing and getting that result. Again, I'm checking is it number or not. If it is a number, again the result will come as a true. If the both are result true, then the number will come as that exact position number. I'm just storing that position number into a match index. Then finally, I'm applying if formula. In if formula, also my first condition, if that match condition is number, if it is true, then I'm just applying index formula. Again, index formula, the first thing we can store that array value, that means that list of values, then the row number, the position number, the previous step. If I add the position number, it will return that value. Okay, this is how I'm just adding. Why I'm applying this way? Let and lambda have that looping systems. Okay, using these methods, we can extract this one. Maybe you follow maybe these methods, you will get the same results, and you can practice based on your requirements. This is how this let function will help. Thank you. It's already close to 6. Quickly, I'll show you how to post from Tally to Google Sheet. Let me open my Google Sheet. Sorry. Max to max 5 minutes. I'll finish. These are all made append, and let formula will help a lot for who is working regularly on data sets. At least if you know basics, then you can take a help of some other AI tools. Okay, anyhow, here also there is a to post data from Tally to Google Sheet. There we need to follow two methods. Number one, we have to create one small TDL to post data from Tally to Google Sheet. The second thing, the Google Sheet will allow data through two methods. One is Google default APIs. Second thing, Google app script. I'll show you quickly how app script will work. Here, I already created one sheet, Google Sheet. In Google Sheet extensions, there is an app script. It's a G script. We call it as a Google script, or you can call it as a G script also. For this one also, you can take help of AI tools, again, ChatGPT, Gemini, or DeepSeek, and others. If you know basics, you can write this script also. This is very simple script only. You can write this script also. Okay, here we can find, okay, anyhow, first I'll show you how this will work, then I'll show you steps. Here we can get deployment ID. Here Chrome. Okay, any data is there in this? There is one line of receivables. There is no payables. Okay. Let me we'll see how it will load. Here I have given button. If you click and upload it, this outstanding data will go to Google Sheet. I'll show you later the steps how this will help. So the record has come to Google Sheet. If you have large data set also, it will come. Okay, already data is there, right? We'll upload this data, company data. You can monitor from here also. If there is a large data, it will take sometimes minutes of time. Because there is a large data, that is why it is taking time to construct the base data. Yeah, now it is updating. You can set time also in Tally, maybe every 5 minutes, every 10 minutes, or every day once, daily once, or standard time every 1 o'clock, 2 o'clock, or evening 7 o'clock. Based on that, from Tally to Google Sheet, the data will transfer. Based on this group, based on this bill number and client name and this amount, you can work on here. And also using the G script, you can create some more templates to trigger notifications to your customers also every day or every week or based on due date. You can trigger it. That is also is possible. Because of the time limitation, I'm just showing this much. See, the data is posting. Still the data is posting. Okay, I'm just quitting my tally. For management review purpose or aging analysis reports, you can construct here, you can send it from here, your aging reports every week, also if required for your management review purpose. See, this is how it will come, but how we can construct in Google Sheet. Quickly, maybe in a minute, I'll show you how we can create app script. I just created one sheet. Here I need, I'll show you one sample only. Bill number, bill date, bill amount, party name. Okay, we'll go to ChatGPT. We'll ask ChatGPT, write G script code to post to sheet. Okay. C URL means it will help for Postman. I'll show you through Postman. CRL. Fields are much. Just if you write whatever you want, a system will have the GPT will understand. I given very simple general manner. Here it will give you steps also. See, it's already drafted that code. First thing, we'll copy this one. It is saying go to Google Sheet. Second one, extension app script. This is Venu extensions app script. Yeah. Then GPT will tell you after copying this code, there are steps: deploy management web X. Okay, deploy web URL. Okay, here I follow that. New deployment. Here we'll get app, and we will give some name for this project. Done anyone. Deploy. It will ask first time for authentication. First. It's already 6 o'clock. I given access of this sheet. So this is my deployment ID. Copy it. Okay. Okay, we'll take complete URL also. Web URL. Okay, we'll go to Postman. We'll go to ChatGPT. After deploying, as given URL, you can copy and paste it here. Scheme. Here we can add that web URL app. Otherwise, you can copy entire code. link, you can paste it here. Come to body. So already there's some information. We'll try to post. Yeah, success, data posted successfully. Very simple manner. I just use ChatGPT. I'm able to post from Postman. If I'm able to post data from Postman, you can integrate from any application, Tally, Excel, or Zoho, or any in-house application, SAP, anything you can use, and you can post it to Google Sheet. So very simple. I just used with a small content here. GPT has helped completely with G-script and also Postman link. But for Tally development, GPT is not supporting. Okay, anyhow, you can use for other applications. Thanks. Thank you so much. We covered all the subjects, all the topics, the 4 topics. Number 1, merge and append. Number 2, multiple companies trial balance extraction. Number 3, late. Number 4, Google Sheet integration from Tally. Additionally, bonus, I showed how to create Google Sheet and that script using ChatGPT also. Thank you so much.